The law of tort. Novus actus interveniens. Causation must be established in all torts where damage is an element of the cause of action. To demonstrate causation, the claimant must establish that the loss they have suffered resulted from the defendant's act or omission. In most cases, a simple application of the but for test will resolve the question of causation in tort law. That is, but for the defendant's actions, would the claimant have suffered the loss? If yes, the defendant is not liable. If no, the defendant is liable. Where there is an intervening act, this may break the chain of causation, removing liability from the defendant. This is known as a novus actus interveniens. The legal test applicable to determine if the chain of causation is broken depends upon whether the new act was that of a third party or an act of the claimant. Where the new act is of a third party, the test is whether the act was foreseeable. If the act of the third party was foreseeable, the defendant remains liable and the chain of causation remains intact. If the act of a third party is not foreseeable, this will break the chain of causation and the defendant is not liable. In Home Office v Dorset Yacht, the actions of the young offenders in stealing the boats was foreseeable, so the Home Office was liable. Whereas in Lamb v Camden, the court held it was not foreseeable that squatters would move into an empty property. This suggests a high degree of foresight is required. Where the act of the third party is negligent, this is more likely to break the chain of causation. In Knightley v Johns, the negligent action of the police officer in directing the claimant to drive through a tunnel on the wrong side of the road broke the chain of causation. Where the new intervening act is that of the claimant, the test is whether the claimant acted reasonably in the circumstances. If the claimant's actions are deemed reasonable, the chain of causation remains intact and the defendant is liable for the actions of the claimant. If, however, the claimant's actions are unreasonable in the circumstances, the chain of causation is broken and the defendant is not liable for the actions of the claimant. In McHugh v Holland, the claimant's action of jumping down steps with an injured leg was deemed unreasonable. In contrast, a doctor's actions in Baker v. T. Hopkins & Son Limited in going down a well with dangerous levels of carbon monoxide was not considered unreasonable as he was attempting to save lives. In summary, causation is generally decided by the but for test. However, where there is an intervening action, the courts need to determine if the chain of causation has been broken. The legal test applicable depends on whether it is the act of the claimant or the act of a third party. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.